On the side. Other side. So it's orange on the side. Okay. Okay. Welcome, everybody. Thanks for coming tonight. My name is Catherine Booth, and I'm the director of the Criminal Division of DC Law Students in Court. I'm also the organization's pro bono coordinator. On behalf of DC Law Students in Court, and most importantly, on behalf of the clients that we serve, I want to thank each and every one of you, and to everybody watching this live streaming, thank you as well for taking time out of your very busy schedules to help us protect some of our community's most vulnerable members. I'm not sure how many of you guys realize this, but DC is in the midst of a criminalization epidemic with disastrous consequences for the health of our entire community. This is for many reasons, but primarily because of how a brush with the law stains background checks and subsequently curtails the potential for full, healthy employment. In fact, according to a report put out by the Council for Court Excellence, among employable citizens on correctional supervision during 2015, 71% reported that they were unemployed. This problem is not unique to people whom were actually convicted. In any given year, over 10,000 people on average are arrested in DC, but are never ultimately charged with committing a crime. They have never had a court date, they've never appeared before a judge, but they were arrested. And because in DC, like in other cities, arrests appear on background checks, that fact alone will prevent many of these individuals from securing meaningful employment. Here's where you guys come in. The only way to seal a DC criminal record is to submit a civil motion to the court, which often requires a legal analysis of an individual's record, a strong legal argument that it's in the interest of justice to seal that person's record, or an argument that the person was actually innocent. As a result, it is very difficult for someone without expertise to file a successful sealing motion, particularly because the government can oppose a motion to seal. Record sealing is a service that very few legal aid attorneys provide and that a large number of low-income people need. Our program is one of the only places in the district where indigent individuals can obtain attorney representation to seal their criminal records in order to put the past behind them. We are grateful to have you guys here tonight, and we hope that you will join us for our Expungement Fair on October 23rd, where we're partnering with the DC Mayor's Office to help a large number of DC residents clear their DC charges from their criminal records. We're pleased to announce that we have over 150 clients currently signed up, and we expect those numbers to dramatically increase over the coming days. Before I close, I want to make an important observation about the community we serve. Nearly 62% of our record sealing clients are male, and almost 90% are African American. Through our efforts so far, the courts have granted nearly 100% of our motions to seal criminal records, giving many a newfound chance at employment and education. I make this observation to point out that the work we're doing here isn't just a matter of economic justice, but of racial justice as well. Make no mistake about it, our community has built what we could rightfully describe as an undercast of poor Black and brown citizens who are barred from meaningfully participating in society. But with your help, we hope to turn the tide. We can begin to break down the barriers that prevent our community's most vulnerable members from obtaining healthy employment and becoming meaningful, contributing members of society. We can make sure that families have caretakers who can protect and provide, that children have role models who can help blaze a path to upward mobility, and that everyone has genuine access to second chances. We all deserve the opportunity to meet our potential. If you want to support the work we do here at DC Law Students in Court, please sign up to volunteer at our Expungement Fair on October 23rd. And please consider donating to our efforts by heading over to our webpage at dclawstudents.org or be on the lookout for our emails. Thanks again. At this time, I'm going to hand over the mic to my colleague, Adrian Madsen. He's a supervising attorney in our criminal division, and he's going to be explaining the DC record sealing process in DC and how to help successfully seal someone's criminal record. Thanks.
Good evening, everybody. How is everyone doing? Good. Thanks for joining us, as Catherine said, and thanks for your interest in being part of something that we, I think, quite a while ago recognized as an integral part of the criminal defense system. We see this sort of as at the far end of the criminal defense spectrum, and something that often goes neglected in an area where there is a very big need and where there is a very real opportunity to make a big impact and positive impact in in folks' lives. As Catherine mentioned, a couple of collateral consequences or direct consequences in some cases of an arrest record, but just to go over a few more of those so that we sort of, I know that we're all here to do expungement, but just sort of to see the many ways in which having an arrest record, again, even if you've just been arrested, not even charged with a crime, can affect people's lives. I think it's important to keep that in mind when doing this work. That can include the obvious things that Catherine talked about, like employment. That can include occupational licensing, housing, the inability to move to other neighborhoods, right? Not only because of the inability to participate in certain subsidized housing programs, but things like your criminal record can affect credit score. In terms of full participation in your own children's lives, we've had clients who had kids who attended private schools, or even in some cases, public schools, where they were required to do one of two things, and that was either to volunteer a certain number of hours at the school, or to pay a fee in lieu of that. And some of our clients, because of their background, weren't able to do the volunteering in the school because of background checks required by the school. And we've been able to help clients get over that barrier. Serving as a foster parent, serving as an adoptive parent, there are all kinds of ways that having a criminal record or even just an arrest record can affect somebody's ability to, again, fully participate in society, their own children's lives, and to move on, and as Catherine talked about, to have a second chance. Civic participation, DC laws are better than some jurisdictions regarding voting in terms of criminal convictions, but just because somebody's case exists here doesn't mean that might not affect their ability to vote in another jurisdiction if they move. Again, disqualification from federal programs, immigration consequences, which we'll talk a little more about at the end, but there really I think a couple of years ago, the National Association of Criminal Defense Lawyers did a report where they cataloged the number of collateral consequences that they could identify from all states in the country. And I think it reached over 43,000 is my memory, just an insane number of consequences that flow from being arrested or convicted. So very big need, very big problem. Catherine talked a little bit about who this affects, but I just wanted to talk about this a little bit more because I think I'd be doing us and our clients a disservice if I didn't. There's close to 36,000 arrests in DC every year. That varies a little bit from year to year. These numbers are from the Council for Court Excellence, a local nonprofit organization here in the city. About 30% of those cases, so meaning 10,000 or more people are arrested each year in DC and have a record despite the fact that they've been charged with no crime. That is, the police arrested them, the prosecutor looked at the facts of the case and decided that they were not going to prosecute that case, either because they couldn't prove it, there was a constitutional violation, or for some other reason. But in any event, they decided not to charge that person. But moreover, the racial disparities. The demographics of the city have changed pretty radically over the last 15 years, where now African Americans make up less than 50% of the city's population. But if you look at both the DC jail and the Bureau of Prisons, where anyone convicted of a felony in DC would go to the Bureau of Prisons, DC does not have its own prison. The racial disparities that you see there are stark. More than 90% of the people at the DC jail, so many people being held pre-trial, are African American men, and more than 96% in the BOP are African American as well. And that's not because, as to state the obvious here, that people of color are committing more crimes. That's because of a racially discriminatory criminal justice system is having that effect. So just in terms of who our clients are, this is who's going to be reflected in the folks that we help. And so we hope, again, that you'll be able to join us on the 23rd. But just keeping that in mind, who our clients are, I think, should inform the work. I don't know everybody's background. I know that you all maybe have come from a variety of sources, so we just wanted to talk first about a few basic terms that are going to come up throughout the training as we talk about here what are the different ways to try to have records sealed. And I should say, if anybody has any questions at any time, please feel free to stop me. Don't feel shy. If there's something I'm saying that's not making sense, please feel free to stop me. I know that's not an option available to people that are live streaming, but for those of you here, please do. Here in DC, what we have is record sealing. We use the word expungement in our name because that's a word that clients recognize as the process of shielding records from view in some way. But so sealing, like it sounds like, is restricting the availability of records in some way. We'll talk more about the different forms of relief that are available under DC's record sealing laws in just a minute. Expungement, on the other hand, is eliminating all records of an arrest, charge, or conviction, which we don't actually have here in DC because of the way the laws are set up. There is something that comes close that we'll talk more about, but that doesn't actually exist here in the city. Disposition, the final legal outcome of a criminal case. That's going to be important when we're talking about some of the forms of record sealing here. A conviction, and I don't mean to state the obvious here, but I just want to make sure we're all on the same page about these things. So generally, that's a finding of plea or a plea of guilt by the accused, which subjects somebody to punishment by the court. That is by a guilty verdict again, or by a plea of guilty. This is also defined where you're going to find most of DC's record sealing laws in Title 16 in Chapter 8. There's a definition 6 in there. We can see much of this as well. So a non-conviction, by contrast, is a disposition that doesn't result in a finding of guilt. That can be from not papering charges, like we talked about. That's somebody who's arrested by the police but never charged by the prosecutor. A dismissal by the court as a sanction for some reason. Dismissal by the government because somebody has completed a diversion program. You'll commonly hear those referred to as deferred prosecution or deferred sentencing agreements. A not guilty verdict at trial. Again, despite a not guilty verdict at trial or any of these outcomes, the record of a case is going to remain on somebody's record until and unless a judge grants a motion to seal that record under DC law. There's something we'll talk more about as well, the Youth Rehabilitation Act. If a conviction is set aside under that can also be a non-conviction for record sealing purposes. And finally, off papers. And this is going to be important because there are a lot of waiting periods for some types of record sealing, which we'll talk more about. That's when a person has satisfied all their obligations to their court. So just as an example, if somebody is convicted of a misdemeanor offense and the judge sentences them to, they say, I sentence you to 180 days, I'm going to suspend that 180 days in jail and give you a year of probation. Being off papers would be when they completed that year of probation, assuming they did that successfully. So again, that's whenever, in the case of a conviction, that's at the end of the sentence. And as you'll see here, that can be a really long time, and why there's a big need for change in DC's record sealing laws, which we'll also maybe talk a bit about as well. Any questions about any of these terms? Yes, please.
So if a person has juvenile records, and definitely up to process
Well, so I guess I would answer that in two ways. So one, the laws that we're talking about here are only governing adult record sealing. There are separate provisions that govern juvenile record sealing. In terms of whether or not, I'm sorry, your question was whether trying to have records of a juvenile case sealed would, not that I'm aware of, that's something I've come across, but these laws are about adult record sealing here. There is separate provisions for juvenile record sealing that are a little bit more limited. Okay. Yes, sir. Yeah. Yes, and we as we go through the forms of record sealing that exist here, we're gonna answer that. But that's a great question. Yeah. Okay. So the two primary ways that you can go about trying to have record sealed, these aren't the only two, but the two primary ways are actual innocence and interest of justice. Under actual innocence, as you can probably guess, what you are having to prove there, despite the fact that you weren't convicted, is that your client was innocent of the offense or offenses for which they were arrested. that is goes on a case-by-case and a charge-by-charge basis. So what I mean when I say that is, if someone was charged with 3 offenses in a criminal case, it would be possible for the judge to find them innocent of 1 or 2 of those things, but not all 3. And it also goes on a case-by-case basis, meaning your ability to have that record sealed is solely dependent on your actual innocence motion in that case. What happened in any other case doesn't have any impact on your ability to have records of that case sealed on grounds of actual innocence. Like we said, the burden is on the movement. We'll talk about what the standard of proof is that's required there. And again, this is despite the fact that there's no conviction. We see some potential constitutional issues there, but the burden is on the movement under the statute to prove innocence. There is no waiting period. That is, if I was arrested today and tomorrow my case was no papered, that same day I could file a motion to seal the records of that case on grounds of actual innocence. There's no waiting period at all. Again, it's case by case, charge by charge. The case can't have resulted in a conviction, and the prosecution has to be over in order for you to file this type of motion. The relief, and we're going to go through these in more depth as well, but the relief, if the judge grants a motion, is very complete. It's the closest thing to expungement that you'll find in DC. That is, you are restored in the eyes of the law. It's as if the arrest didn't happen. There's a couple of exceptions to that that we'll talk about for immigration purposes at the end. But that, as a general matter, in the eyes of the law, it's as if the arrest didn't happen. The records can only be opened on a showing of compelling need. I can, by court order, and I can say that we've filed hundreds of these and had quite a few granted on grounds of actual innocence, and I've never come across a circumstance in which someone even moved to reopen the case on a showing of compelling need, let alone had that granted. So it's a very complete form of relief. The second way, which is much less straightforward, that we'll talk about here, is called interest of justice. Again, it's in Chapter 8 of Title 16. And what the court is considering there, that we'll talk more about some of the factors, is whether or not it's in the amorphous concept, the interest of justice, to seal records of this case. The eligibility is determined not by looking at just the one case that you're trying to have sealed, but by looking at somebody's entire criminal history. There are a number of waiting periods and other requirements that we're going to talk about here that apply if you're trying to have records of a case or cases sealed on interest of justice. Basically, in the end, the court's going to, if the cases are eligible under the law, the court's going to do this balancing test and say, is it better for these records to be non-public versus any public interest in having them remain available? Again, there are waiting periods, which we'll talk about in a minute. Only certain types of cases are available for relief here, depending on the charge and the outcome. So some big rules that you're going to see here, unfortunately, that exclude a number of people from seeking relief in record sealing are that no felony convictions can be sealed, with the exception of one type of felony case, that is the Bail Reform Act, that's basically failing to appear in a felony case. So right off the top there, in terms of the number of folks that can be helped by record sealing, and maybe some folks who need the help the most, unfortunately, the DC law currently doesn't provide for that. It's not just felonies. There's some misdemeanor convictions that also cannot be sealed as well. To go to your question, sir, in terms of the relief that you are afforded if the judge grants a motion, the records are sealed to the general public. So if you or I went to the courthouse afterwards and looked for records of this case, we would not see it if the judge had granted the motion. But the records stay available to courts, law enforcement agencies, prosecutors, and we'll talk more about some of these as well. But also maybe more importantly, to occupational licensing agencies and to licensed facilities that work with children. So the relief that is afforded under 16803, while it can make a very big difference in many people's lives, is much different from that afforded for motions on grounds of actual innocence. Okay, so to go a little bit in more depth here, because again, we're hoping that as many of you as possible anyway will be able to join us on October 23rd. And one of the things that we want to do there is we're going to have clients there with their records in advance, and we're hoping that day even to be able to prepare some motions. So I really want to give you the best idea of how that would happen. So if I seem like I'm going in a lot of detail, I apologize, but that's the goal here. So again, this is only available in cases that haven't ended in conviction, right? So if somebody was charged with two things, and one of those things they were convicted of, and one of those things they were not convicted of, currently the court takes the position that even that thing that they weren't convicted of, they can't file a motion to seal records of that charge on grounds of actual innocence, right? So the case can't have ended in conviction. Again, the movement has the burden, right? That's us, of proving that you were actually innocent of the thing that you were arrested for. Again, even an acquittal, like a jury, 12 of your peers found that you were not guilty, is not enough. The standard by which you have to prove innocence goes up once more than 4 years have passed since the termination of prosecution in the case. Sort of counterintuitive in many ways. You'd think as time goes on that the value of the records would diminish, right, and people would be able to have it sealed, but that's not the way the law is set up currently this way. So the standard, if 4 years or less have passed since the termination of prosecution, and so that's whenever the case ended without conviction, whether that was being no-papered, whether that was being dismissed for want of prosecution, whether that was being dismissed as a sanction by the court, being found not guilty, whatever that date is, if it's been 4 years or less since that happened, you have to prove innocence by preponderance of the evidence, so more likely than not that your client did not commit the offense or offenses for which they were arrested. If it's been more than 4 years, you have to prove it by clear and convincing evidence, which anybody remember generally what the language is around clear and convincing evidence, like what that means? Okay, so the sort of the language that the Court of Appeals has used a lot of times is a firm belief in the mind of the trier of fact that the thing you're trying to establish is true or not true. So basically, it's somewhere between beyond a reasonable doubt and a preponderance of the evidence, right? Not as high as beyond a reasonable doubt, it's higher than a preponderance of the evidence, but it's a high standard to meet. We do it frequently, right? But it's a high standard to meet. Again, the existence of other cases doesn't determine eligibility as to this case, right? So the fact that somebody had 2 convictions and 1 non-conviction, they can still file that motion to seal the records of the non-conviction on grounds of actual innocence. It's not affected in any way by those other cases. Again, there's no waiting period like we talked about before, and we talked about the really complete relief that there is. Yes, did you have a question? Yeah, so basically the worst outcome in the case controls the eligibility. So like if I was charged with 3 things in a case, and 2 of the counts found not guilty of, and 1 of them found guilty of, you cannot have records of that case sealed on grounds of actual innocence, right? Not either of the other charges, not anything on grounds of actual innocence. And so often, as we'll talk about in a minute here, sort of the form of proof is going to take that this is going to take. You might be thinking like, well, how do I prove my client's innocent? How do I prove that this thing didn't happen? Is often going to be in the form of affidavits, either from your client or somebody else that we'll talk about here in a second. But the first place to start is figuring out what are the elements of the offense, right? Because if we're trying to prove that someone is innocent of something, if we prove by the requisite standard that one or more of the elements of the offense are not satisfied, then we have, by definition, proven that they were innocent, right? We don't have to prove that none of the elements are satisfied, just one. And so first, you want to figure out what the elements of the offense are. These are available in Lexis. You can look in the DC code. DC does a pretty good job of also making records, the DC code available online. To start there, to figure out what are the elements of the offense, right? Because in order to figure out whether I can prove innocence, I need to figure out whether or not what the elements of the offense are. From there, we also recommend, and some of these records, again, are going to be available on the 23rd, some but not all, looking at things, court records, that can include the Gerstein affidavit that's filed in the case, motions that were filed in the case, other things with like factual allegations about what took place in the case. Sometimes, we'll sort of take a more exhaustive approach and use the Freedom of Information Act to get other records. Might reach out to the person's trial attorney to maybe they did other investigation in the case that could be helpful. Really gathering as many sources of information that give us an idea of what happened, to both shape our argument and to inform who we want to get affidavits from as well. Sometimes, again, of course, you're going to have to take a step beyond the code or the case law and figure out, well, maybe there's a sort of a reverse sufficiency issue. One way of proving, sometimes the government doesn't allege the right things. And what you have to prove is not that no crime occurred, but that the crime the government alleged didn't occur. Right? And so an example of that might be if somebody was charged with assault with significant bodily injury, which requires, as it sounds like, significant bodily injury, which means a particular thing, and maybe the government didn't allege that with the requisite standard on the case. And then you've got a very easy motion, right? Or maybe somebody charged with operating after suspension, driving on a suspended driver's license. We see that frequently when people's driver's license wasn't actually suspended. And so, like, the driving record is the thing there that can prove, well, hey, the government's own documents show that this person was innocent of this offense. Obviously, this is all going to be sort of condensed on the 23rd if this is happening. You want to interview your client, right? You want to talk to them about what happened, having the benefit of all these other records, and knowing what the elements of the offense are to sort of be able to pull and tease out what are the important things versus what are the not important things about this event. Because again, the actual innocence motion is focused on proving innocence as opposed to the other reasons why it might be compelling for the record to be sealed aside from that. Again, this can be, like I mentioned, sort of like a necessary element the government didn't even allege, right? So then you've got a strong argument there. Or by contradicting government evidence, either through the form of affidavits, other documentary evidence, as the case might be. And an affidavit, is just a sworn statement about what the person's version of events, which might say, this is what I did on that day. There was a misunderstanding about what happened, or it might say, I wasn't there at all. I have no idea. This was a case of misidentification. And to go through with that with your client, have that notarized, and sort of that would be attached to the motion as the evidence in support of the legal argument that you're making in the motion. I know that was very brief, but are there any questions generally about actual innocence? Okay. So in terms of interest of justice, the second way that we talked about is much less straightforward than the other way that we talked about before. That is actual innocence. And unlike actual innocence, with interest of justice, the records are sealed to the general public, but remain available to those other agencies if the court grants the motion. You can see a list of those in the citation that's provided there. The first step in interest of justice, where most of the work is figuring out whether the case or cases are or not eligible to be sealed. And this is probably the more confusing part of this. We frequently get responses from the government or the court where it's clear that they also don't understand the statute. It's not written very well, but I'll do my best to explain it and make it easy. At the event on the 23rd, we'll also have a cheat sheet that will sort of make this easier to figure out as well. Once you get the hang of it, it's not hard, but they use terms that don't mean what you think they might mean. So again, this is going to be determined by looking at somebody's entire criminal history. So even though DC courts only have the ability to seal records of DC cases, what happens in out-of-state cases can affect somebody's ability to have records of a DC case sealed on interest of justice grounds. And the things that are going to control both the waiting periods and eligibility largely are the charges, the outcome of the cases, and the waiting periods. And we'll talk about what those waiting periods are more specifically in a second. But somebody might be eligible to seal only part of their record, for example, on interest of justice grounds. That's not uncommon. One big rule is that unlike actual innocence, where you can file in one case at a time, and that's not affected by your ability to, by the existence of other cases, somebody must seek sealing of all eligible cases at once. So that often means waiting for a bunch of waiting periods that are running concurrently to all end before doing that. And we'll talk more about what that means. The second step, and we're going to get into the specifics of the eligibility here in a second, but the second step generally is to draft the motion, where the focus is much more biographical rather than factual and legal about what happened and why your client was innocent. You can see the three primary factors that the court's going to consider. There's a list of other factors that you can also see there at 16803H, but the interest of the movement in sealing the record, we talked about many of the examples of that: employment, housing, being a foster parent, right? There's really a number of ways that it's in somebody's interest, obviously, to have the record sealed. Any community interest in retaining access to the record, if a record's 30 years ago for a non-conviction, it's pretty hard to argue that there's any community interest in retaining access to that. But so highlighting the reasons that there is not a community interest in retaining access to that is often the way that we would use that factor. And the community's interest in, as it says here, in furthering the person's rehabilitation. If somebody's employed, if they're housed, they are much less likely to become involved with the criminal justice system again. And again, there's other factors in the statute that the court can consider but doesn't have to consider as well. So in order to determine eligibility, so a place to start here is figuring out, are we talking about a misdemeanor or are we talking about a felony here? That's a good place to start because, again, we talked about felony convictions. The overwhelming majority of them can't be sealed. And so the way we can figure this out is by looking at the case number. So case numbers in DC follow a certain pattern. The first number you're going to see is the year. Then there's going to be a 3-letter abbreviation, and then there's going to be up to a 6-digit case number. So there are usually leading zeros there. We just omitted them for this purpose. The 3-letter abbreviation is going to tell you whether that's a misdemeanor or whether that's a felony. So CMD is criminal misdemeanor in this case, and that, as it sounds like, is punishable by a year or less. Some other misdemeanor abbreviations that you're going to see are criminal traffic, CTF, CDC, which is Criminal District of Columbia. There are 2 prosecutorial bodies here, the Office of the Attorney General, which prosecutes regulatory offenses and juvenile offenses, and there's the United States Attorney's Office, which prosecutes the overwhelming majority of adult crimes. But CDC is those that you will see that regulatory offenses, things like drinking in public, not paying metro fare, mostly very low-level regulatory things. PAF is another one that you'll see, stands for post and forfeit. There is a process by which for certain, I think they're exclusively actually DC misdemeanors, someone can pay a certain amount and forfeit their right to a trial. So the posting is, I've been arrested, I go to the police station, the police arrested me on suspicion of one of these minor crimes. I have the option, if I meet certain criteria, to pay this amount of money, and I don't have to go back to court, and it's not a conviction. But that's why you'll see post and forfeit as well. Domestic violence misdemeanors. So the domestic violence unit, I think, came into existence in 2001. So cases before that, you would have the same abbreviation regardless of whether they were a domestic violence offense or not. We'll talk more in a minute about why the domestic violence abbreviation is relevant to this statute and determining eligibility. But that is things involved. It's a very broad definition. It includes not just what you traditionally think of as domestic violence, but there's a really expansive definition of what constitutes either an interpersonal, intimate partner, or interfamily violence here in DC. That can include like the romantic partner of someone that you once dated before, right? It depends on this relationship between the complaining witness and the accused. Felony cases, so up until about 2005, they would all have the same abbreviation, so it would say 2005 FEL for felony, very self-explanatory. Now that has changed. The felonies are grouped into different groupings. CF1 is the most serious felony cases. Criminal felony 1, it's things like murder, rape, very serious things. CF2 and CF3 actually don't vary. It doesn't have to do with their seriousness, but whether or not somebody is held pending trial. That's why they're on different calendars. But again, those are other felony abbreviations that you'll commonly see on a record. And sort of maybe to make it more concrete, the records that we will have available on the 23rd are going to have a list of case numbers on one side, charges, and dispositions like we talked about for and outcomes there. So you're going to see like 2015 CMD 1111, somebody was charged with simple assault, and the outcome was that it was dismissed for want of prosecution, right? So you're going to see all these things on a paper together, sort of in one place, telling you, and so that's why this is the starting point, figuring out, well, what does this case number tell me about what this case was, whether it was a felony, whether it was a misdemeanor. You may also see another abbreviation, FUG, fugitive. That's just when somebody was arrested in DC and there was, or otherwise came into contact with police, even if they weren't arrested, going to be arrested otherwise in DC, and they had a warrant from another jurisdiction. DC creates a criminal case just as a result of that. So even if the police were just running my license and they were going to let me go, I had a warrant from Maryland. The police are going to arrest me and create this fugitive case. So there's a separate provision we'll talk about that deals with that. That's pretty straightforward, but that's another abbreviation that you may see. Yes. So we are having folks pre-register for this event, and so for those that do, we intend, as at least those that pre-register far enough in advance, we're going to have a significant amount of their criminal history. There may be some documents that we might not have, but yes, we'll have a record that has, again, all the cases in DC. Yeah, sure. So, the answer is, for those who don't know, who haven't used, CourtView is the system used at the DC Superior Court that they maintain their records there. CourtView is a place where you could get that record, and that's where these records are coming from. There isn't, unfortunately, currently remote access to CourtView, at least not fully. You can look at records of cases online, but not have like images of documents and things like that. So for the majority of folks, we're hoping to have records available there. But if we didn't, that is a place where you could get that. Yes. In terms of out-of-state records, Maryland generally makes enough of its records available online that you can determine the relevant things here. That is what somebody was charged with and what the outcome was through a website that we can share. Virginia generally does the same thing, except they break it down by jurisdiction, so you sort of have to know where somebody was arrested in order to know where to look. But so a common question that all folks are going to be asked is whether or not they've been arrested in any jurisdiction other than DC. Okay? So we've figured out, is it a misdemeanor or a felony, right? And we've figured that out based on, generally speaking, not on the case, generally speaking, on the case number. That doesn't always control. Somebody could plead guilty to a misdemeanor in a felony case, right? So you want to double check, but that's a general rule of thumb. And there are three sort of categories of offenses that are generally eligible for sealing on interest of justice grounds in DC. The first of those is what a good name here, eligible misdemeanor non-convictions. Now, when I say eligible, I don't mean that the case is eligible under the law to be sealed. What I mean is that the DC Council has identified in 16801 in the definition section, they've categorized certain misdemeanor offenses as eligible misdemeanors. So they are saying, don't think about the waiting periods yet, right? They're just saying, if it's on this list, at some point, if it didn't end in conviction, it's going to be eligible to be sealed. But the use of the word eligible here is kind of unhelpful. So there's just these list of offenses that are, and the way they do it is not by listing those that are eligible, but by listing those that are not. So there's this list of ineligible misdemeanors in DC Code 16801. And that's going to tell you not what you might think, whether or not something is going to be eligible to be sealed, but the first starting point is how long you're going to have to wait to try to have records of that sealed. So that the second category, and we'll get more into this in a second, is ineligible misdemeanor non-convictions. Now, the fact that you might think, well, that doesn't really make any sense. Why is something eligible to be sealed if it's an ineligible misdemeanor? That's because it's on this list, but it's only ineligible to be sealed at any time if it ended in a conviction, so which we'll get more into in a second. The third thing is eligible misdemeanor convictions, and we talked about there's only one type of felony conviction that is eligible to be sealed under any circumstances, and that's felony DRA, which again is basically failing to appear in a felony case. Now, the caveat to all this is as long as all the requisite waiting periods have passed, and we'll get to what those are in a second. So again, in the definition section of the DC, Chapter 8 of Title 16, there are some common things that are listed as ineligible misdemeanors. And again, that doesn't necessarily mean that records of that case can't be sealed. That only means that records of that case can't be sealed if it ended in a conviction. So some really common ones that you're going to see are most domestic violence offenses. That's why in terms of talking about the case numbers, when you see that DVM, this is going to tell you this is a domestic violence case. If it ended in conviction, under most circumstances, it can't be sealed. DWI, DUI, OWI, most sex offenses, fraud, so no permit is driving without a valid permit. If that's the second time you've been convicted of that, you can't have it sealed. I don't really know why the council decided that. Again, the DC Council just decided these are some things we don't think you should be able to have records of them sealed if you have been convicted of them. It also includes attempt or conspiracy to do any of those things. There's a long list of them. There's about 40 of them, but the overwhelming majority of them are captured in these 5 bullets here. Most of them you don't see. They're really weird things like, I don't know, like driving a school bus without the right commercial driver's license and things that I've never seen anybody charged with. So I don't really know why they came up with this list, but they did. Some common eligible misdemeanors are things like unlawful entry, which is trespassing here in DC, misdemeanor assault on a police officer, drug possession, threats, simple assault, violating the Bail Reform Act. Those are some common ones that you'll frequently see. Going back to that first category that we talked about before, of things that are going to be eligible to be sealed on interest of justice grounds, are eligible misdemeanor non-convictions. So what is an eligible misdemeanor to start with? It is any misdemeanor that is not defined in 16801 as an ineligible misdemeanor. They sort of defined it in the negative. Like I said, the drafting of this statute wasn't the best, but it's any misdemeanor that is not an ineligible misdemeanor, right? So if it's not on this list and it's a misdemeanor, it's an eligible misdemeanor. So the first question you have to ask in terms of talking about those waiting periods is just that case standing alone. So let's say we have a misdemeanor simple assault, and well, that would by definition be a misdemeanor, a simple assault non-conviction. And that's it. That's on somebody's record. And they can't prove that they're innocent. They have to wait 2 years before they could have records of that case sealed. So if that was the only thing on their record, the answer is yes, it would be eligible to be sealed on interest of justice ground because there's a 2-year waiting period, and that starts when the prosecution terminates in that case, right? So if that's the only thing on their record, then the answer is yes, that's eligible to be sealed. Now, many folks, not all, but have more than one thing on their record. So a second question you're going to have to ask, and this is both as to DC offenses and out-of-state offenses, like we talked about before. Out-of-state offenses can affect your ability to have records of a DC case sealed. The second question is, if they've been convicted of a misdemeanor anywhere, not in the case you're trying to have sealed, but any other case, has it been at least 5 years since the end of their sentence in that case, right? So to take our original example of having, if I had a simple assault non-conviction in the year 2000, and I had a unlawful entry, which is a misdemeanor conviction in the year 2015. Currently, I could not file a motion to seal records of that simple assault case on interest of justice grounds because it hasn't been 5 years since the end of my sentence in that case, because that was 2015, it's the year 2017 now, right? It hasn't been 5 years since that happened. So you'll see there here that this is going to be pretty restricted. Yes? Good question. It is that served, including any period of probation, parole, supervised release. It's not the maximum punishment that they could be imposed for the offense. So the second question is, right, has it been 5 years since any other misdemeanor conviction? And when I say any other, we're talking about going back to just our eligible misdemeanor non-conviction that is our starting point for this example. Then there's a third question. So let's say I didn't have any misdemeanor convictions, but I had a felony conviction in the year 2009. I had a simple assault non-conviction in the year 2000, and I had a felony conviction in the year 2009. The third question is, has it been 10 years since I've been off paper since any felony conviction? And if the answer is no, which in that example it would be, right, because it couldn't have been 10 years, because 2009 was less than 10 years ago, that I couldn't have records of my simple assault non-conviction sealed on interest of justice grounds. Again, none of this is to say you couldn't file an actual innocence in that other case, but you couldn't on interest of justice grounds until that waiting period has expired. And there's another requirement here that's going to be a requirement that you're going to see in all the interests of justice, that you don't have any pending cases. So if, to give another example, if I had again, my simple assault non-conviction from the year 2000, and I had nothing else on my record, but yesterday I got arrested for unlawful entry, that means that I can't have that simple assault non-conviction sealed on interest of justice grounds because I have this pending case. There's one exception to this that we may not need to talk about, but just that if a non-conviction resulted from a deferred sentencing agreement, so we're going back to our original eligible misdemeanor non-conviction, there's something called a deferred sentencing agreement where someone pleads guilty. If they adhere to certain conditions for a period of time, they get to take that guilty plea back, and it's not a conviction, but the DC Council treats it like a conviction if you have a later conviction, which we'll talk more about in a second. But yes, sir. Yeah, sure. So good question. So because so the only out-of-state cases that are going to matter are convictions or pending cases. So if I had the out-of-state case that ended with a deferred adjudication, that's not going to affect the eligible misdemeanor non-conviction. So good question. So that's the first general category of offenses that are going to be eligible to be sealed on interest of justice grounds, that is eligible misdemeanor non-convictions. The second category is ineligible misdemeanor non-conviction. So again, ineligible misdemeanors are these misdemeanors that are on this list in DC Code 16801, and any felony offense other than felony BRA, or actually including any felony offense. There's going to be either a 3 or a 4-year waiting period just for that case, the ineligible misdemeanor or the felony non-conviction that we're talking about. Whether it's 3 or 4 years depends on whether it was dismissed before charging or dismissed after charging. So you remember before we talked about there are nearly 10,000 people every year in DC who are arrested, but there are cases their arrests are no papered, meaning the government doesn't charge them with a crime. That's an example of a case that is dismissed before charging, so being no papered. In that case, that person has to wait 3 years to try to have records of that case sealed on interest of justice grounds. If the case is dismissed after charging, so anything other than being no papered, right, that's being dismissed for want of prosecution, being found not guilty, having the government nolly the case after you complete a form of diversion, they have to wait 4 years just as a result of that felony or ineligible misdemeanor non-conviction. So that's the first question, just like the other one. And these other ones are going to look very familiar here, right? The second question is, has it been 5 years since the person was off papers since any misdemeanor conviction? Again, off papers meaning the end of their sentence from that misdemeanor conviction. 10 years off papers since any felony conviction. And no pending case in any jurisdiction, and the same exception that we talked about for deferred sentencing agreements or DSAs that apply there. So again, and these waiting periods can run concurrently, to be clear, right? If I had a non-conviction in 2015 and a conviction in 2016, those waiting periods that we're talking about in section B1A, the first one, and section B2A, the second one, they can run concurrently. They don't. You don't have to wait for one to go and then wait another 10 years on top of that. They can run at the same time. Does that make sense? The third category of things that are going to be eligible to be sealed on interest of justice grounds are eligible misdemeanor well, there's one felony conviction, but largely eligible misdemeanor convictions. Again, so a conviction for a misdemeanor that is not on that list of ineligible misdemeanors is an eligible misdemeanor conviction. So the first question you have to ask here is, has it been 8 years since they've been off papers for that conviction? The one we're talking about, the one we're trying to have sealed, which is a really long time. Effectively, that amounts to generally at least probably a 9 or 10 year waiting period to try to have records of an eligible misdemeanor conviction sealed. So something we'd definitely like to see shortened. The second question is going to be, does the person have either a felony conviction or an ineligible misdemeanor conviction, not the one we're trying to have sealed, right, but elsewhere on their record at any time, whether before or after this. And unfortunately, if the answer is yes, then the misdemeanor conviction can't be sealed. So to give an example of that, if I had a 1980 robbery conviction and I had a 2005 simple assault conviction, even if it had been 8 years since the end of my sentence in the simple assault case, I can't have it sealed because I have this felony conviction, even though that was now 37 years ago. As you can see here, there's a need for legislative reform, which would definitely like help with that too. But that's the first question you're going to have to ask. So even if the answer is no to that, there's another question, and that is whether that person has any subsequent conviction, again, in any jurisdiction after the conviction that we're trying to have sealed here. So if we had a 2005 simple assault conviction and a 2010 simple assault conviction, the 2005 simple assault conviction can't be sealed at any time, unfortunately, under the current law. So basically, other than something else we'll talk about in a second for things that are no longer a crime that have been decriminalized or legalized, it's only going to be possible basically to have records of one conviction sealed, unless they all happened at the same time, like a global plea in multiple cases and somebody pled guilty in 2 or 3 cases on the same day. In that case, you might be able to have more than one sealed, but generally speaking, the ability to have conviction sealed is very limited. Yes?
So, because DWI,
Mm-hmm. Yep.
You know, that was simple assault. You know, it's something you have to wait 8 years. I'm not talking about states that have DWI, Louisiana. Maybe I'm talking about myself. But I wouldn't say there's a simple assault, something like that. I would not, and I got convicted for something like that. It would take 8 years because I had that other DWI jurisdiction.
Sorry, so I just want to make sure I understand your hypothetical correctly. So, DWI conviction, whatever, some quite a few years ago, we'll call it 20 years ago, just for example, right? And simple assault conviction, anytime. Unfortunately, the answer is the simple assault conviction can't be sealed at all because DWI is an ineligible misdemeanor, and looking at 801 5C, that right, it's an ineligible misdemeanor conviction. Yes. Yep. And again, Felony Bail Reform Act convictions, which are basically failing to appear in a felony case generally.
So that's one thing set by every court, right? So if there's certain times.
Yep. Yep.
Anything after all the
Yes, that's correct. Yeah. Does that make? I mean, when I say make sense, that is it understandable? Not does it make sense as a matter of policy. But, yes. Yeah. So if you remember, one of the if you go back here for a second, one of the requirements is that somebody, well, I don't know where it is, but that somebody seeks sealing of all eligible cases at one time. And so the answer is sometimes somebody has a choice. That is, if I had, let's say in 2015, a simple assault non-conviction, 2016, a simple assault non-conviction, and earlier this year, a simple assault non-conviction. If I wanted to have records of, let's say the waiting period for the first one has expired, right? It's been 2 years, but the other two haven't. If I wanted to file an interest of justice motion, I'd have to do one of two things. That is, either only try to have records of the earlier one sealed and give up the right to have the later one sealed, or wait until the waiting period has expired for all of them. So, non-convictions in other jurisdictions don't have that effect because the DC court doesn't have the authority to seal them. Yes? No, it doesn't mean you can only do it once. It means that, to take an example, if all the waiting periods had expired and I filed a motion and the judge granted the motion, that wouldn't stop me from later, if I was arrested again and the waiting period had expired, doing it again, but only to say that at the time, if the waiting periods hadn't expired, and to be clear, the only waiting periods the movement can waive are the ones resulting from non-convictions. Those other ones, the 5 and 10 year things that we talked about, the government has the ability to waive those. In our experience, they don't very often. You could do it more than once, but you would have to, again, if the waiting periods hadn't expired for any of the non-convictions, you'd either have to wait or give up the right to later try to have those sealed. Kind of a rule that, again, doesn't really make sense as a matter of policy. It's not treated case by case, right? It's treated by somebody's entire criminal record, and for interest of justice, they say that requires making a decision about all these things at the same time. But it wouldn't stop you from doing it more than once if you had a motion granted, were later arrested, and the waiting period had expired. Okay, so we talked a little bit about what the steps were in an actual innocence motion. Those were figuring out the elements of the offense, figuring out the facts about what happened. Here, again, with interest of justice, assuming you've determined somebody's eligibility and you've figured out which cases are going to be eligible, this is going to be much more biographical in nature. And so even though when we have somebody's record and we can figure out their eligibility, which say at the event on the 23rd, we've already figured out somebody's eligibility, we know they're going to be eligible, then what we're looking for is the biographical information about them, right? That's going to be things like what they do for work. And I understand there's a tension here between sometimes like presenting the best case for somebody and the fact that somebody needs record sealing, right? But the ways in which they otherwise contribute to their community, the ways in which the record has impacted them, and the more specific that you can be, in my experience, the better outcome that you're likely to get. That is not just this person has had a hard time getting a job, but they've applied to 37 places and they've been rejected for each one of them over the last year, right? And this potential employer has told them that's because of their record, right? Record sealing is clearly not the only way to for folks to make successful reentry. There are folks who have records that can't be sealed at any time who thrive in spite of those things. But you want to put forward both the best picture of your client and the reasons why these records are continuing to impact them in doing that. So that can include like getting letters from different people in their life. Maybe they volunteer doing this thing. Maybe they're part of a church or another religious organization. One thing judges are often sort of thinking about also is like, let's say this person had a string of cases 15 years ago and then nothing, right? One thing the judge might be thinking about is, in deciding whether or not to seal records of the case, is why are things different now, right? So maybe somebody has gone through drug treatment, if it's drug cases, just figuring out what are those change in circumstances that this person is now on quote unquote the right path, and they're not going to come in contact with the criminal justice system again, right? So putting forward the best picture of your client, which requires good client interviewing. So at the event on the 23rd, definitely for folks who are eligible and anybody who's interested, we'd love to have you join us for that and talk to clients. And these motions are, in terms of the legal argument, are relatively straightforward and can often be put together in not too much time. So there might be even a chance to do that, on the day of the event if anybody's interested in doing that. Again, a resume is a common thing that, and I don't know if we've asked folks, any of them, to bring that on the 23rd, but if not, it would be a good idea. It's sort of a common consolidation of information about somebody that has a lot of the information and questions that you'd be asking about. If not, there's also other organizations in the city that help people put together resumes. Some of those that we partner with, job training agent, workforce development, and other job training organizations as well. Again, it can include character letters, other professional certificates or licenses that they've earned, and anything that's going to give the judge a favorable impression of your client. And then you're going to sort of, again, because we're going to make this as helpful as possible, so you're going to sort of break down the eligibility of each of these cases first, right? In the motion, it's going to be, okay, this case, it's been 2 years since the end of this eligible misdemeanor non-conviction. They don't have any subsequent misdemeanor convictions. They don't have any felony convictions, and they don't have any pending cases. Therefore, this case is eligibly sealed, and here's the reasons why you should seal it. This person, attends their church. They help care for their kids, but this record is really standing in the way of them earning more money in order to be able to support their kids. Right? It's a very normative argument in the end. Some other sealing provisions. The first, which you won't see very often, but is mistaken identity, which could also be, of course, grounds for actual innocence, but this is a little bit different what we're talking about here, where somebody was arrested and gave somebody else's name, essentially, is what we're talking about here, and the police didn't take fingerprints. This is generally in older cases when this would have happened, because now the police generally are taking fingerprints in all cases, but somebody can submit an affidavit saying, that wasn't me, the police didn't take prints. Again, you could also file that on grounds of actual innocence, but it's just another statute that exists. We talked also about fugitive from justice. That, again, is where there's a warrant from another jurisdiction that somebody came into contact with the DC police and they were arrested solely because of this warrant from this other jurisdiction. You are entitled to sealing as a matter of right if you can show a couple of things. That is, that the arrest did not result in federal charges or convictions, which in the overwhelming majority of cases, that's not going to be the case. The person they only have two options here. Either they waived extradition and they were released or detained. So if they waive extradition, they're on the right path there. And that they prove that they appeared in the jurisdiction, they took care of the warrant wherever that was at some point. It doesn't have to be immediately, just at some point before they file the motion. The relief is a little bit better than that you get under 16803. That is under interest of justice. We talked about the agencies that it's going to remain available to, but records of that case would only remain available. A fugitive case sealed would only remain available to courts, law enforcement agencies, and prosecutors. Even if you can't show those things, the judge is still permitted to seal records of a fugitive from justice case if it's in the interest of justice to do so. So basically they'd be considering the same factors that they'd be considering in an interest of justice motion, just about a different type of case. The other one that you are going to see more commonly here, and this is sort of as the city has decriminalized or legalized more things, the biggest one, of course, is possession of marijuana, or simple possession of marijuana. But there is an offense that that provides for sealing as a matter of right if somebody was arrested for, charged with, or convicted of something that is no longer a crime if they weren't charged with or arrested for anything else in that case. So in other words, they were just charged, for example, with possession of marijuana. In that case, it's a very straightforward motion. You're saying the thing that they were arrested for or charged with is no longer a crime. There's this specific statute that provides for sealing of that. If they were arrested for something else that is still a crime, so more than one thing in the same case, one that was a crime and one that isn't a crime, again, the judge is allowed to seal records of the case if they find it's in the interest of justice to do so. So you can sort of see the legislature wasn't very creative here and kept going back to to the same thing. And the relief that's afforded there is the same that's afforded if somebody files a motion that's granted to seal records of a fugitive from justice case. So again, it would just stay available to courts, law enforcement agencies, and prosecutors. So in terms of like the hierarchy of things here, actual innocence gets you the best relief. These two get you some 803.01, fugitive from justice, and decriminalized or legalized offenses get you somewhere in the middle, and interest of justice get you the least relief. Not to say again that it can't make a very and does make a very meaningful impact on people's lives, but in terms of the hierarchy of relief, that's the way it goes. To sort of give an overview of the motion process, the first step, like we talked about, is whether it's interest of justice or whether it's actual innocence. The first step is that you need to figure out somebody's eligibility. Now, for actual innocence, that's relatively easy, right? Did the case end in a conviction? No. Can you file an actual innocence motion? Yes, if you can prove innocence. Once you've figured out eligibility and you've prepared the motion, it's filed with the court. Unlike other motions where the government or opposing party has a freestanding obligation to respond within a certain period of time, with these type of motions, the court has to first order the government to respond. So sometimes that can require following up with the judge, following up with their law clerk to say, hey, I filed this motion last week. You need to issue this order. So that's something that can be a sticking point. Once they do that, they're going to order the prosecutor to respond. The prosecutor's either going to have between 60 and 90 days to do that. In most cases, it's going to be 60. The only case in which it's going to be 90 is that process we talked about before called post and forfeit. So the overwhelming majority of cases, they're going to have 60 days to respond. And in our experience, they generally take every one of those 60 days, and sometimes we'll ask for more time at the end of that. But so it's not a quick process in terms of from start to finish. Again, at the end of that, if the government asks for more time, the court usually will give that to them, maybe another 30 days. If the government doesn't respond, we would file a motion to treat the motion as conceded. If the government files a concession, the judge, in the overwhelming majority of cases, I don't think I've seen anywhere the government filed a concession and the judge didn't grant the motion. So if that happens, you're in good luck, in good shape. And we'll come back to the certification process afterward. But the government can also oppose the motion. They more commonly do this in actual innocence cases. I don't know, it's sort of like this knee-jerk reaction. Somebody says, I'm innocent, and the government says, no, you're not. If that happens, the judge can decide the motion on the papers and deny the motion. There's case law about when it's appropriate for them to do them and when it's not. But the judge can also grant the motion on the papers without having a hearing. Or the judge can order you to respond to some argument that the prosecutor has put forward. That's another possibility. Or the judge can order a hearing on the motion. That doesn't happen too often, but we've had a few cases lately that have gone that way, and it's sort of like a mini trial about whether or not you can prove your client's innocence as the things. You call witnesses, the government calls witnesses, you get to cross them. It seems like a lot of effort for the government to go through, but and to require someone to go through in order where they weren't convicted in the first place and they're presumed innocent. But that is something that can happen. So after the outcome of whether on the hearing or on the papers, the judge can either grant the motion or deny the motion. If they grant the motion, sort of the implementation of the sealing, how that happens is that we talked about the different agencies that are affected by the court's order. What some of those were, those are the Pretrial Services Agency, CSOSA, the Court Services and Offender Supervision Agency, the FBI, MPD, the Metropolitan Police Department. All of these agencies get this order from the court, and they have 90 days to take the steps that are required in the order, which are generally, if it's an interest of justice motion, removing records of the case from their publicly available records, or if it's an actual innocence motion, sometimes to do more than that. And they have to certify to the court that they've done that. Now, in practice, that's an administrative headache and sometimes take longer than 90 days, but that's how the implementation of the sealing actually happens, right? Depending on, there's many third-party contractors that do background checks and things like that pull records from different sources, but if they're pulling records, for example, from the FBI, which is a common source, the FBI will have taken the steps that are required in the order. They're actually pretty good about it, more than some of the local agencies here about doing it, but that's how the sealing actually comes into place. Yeah, that's an overview, sorry, from start. Any questions about the motions process there? Yes? It does not directly. That is, the court's order only applies to public agencies. However, under the Fair Credit Reporting Act, if made aware of the sealing, they would have an obligation, that is the credit agency or whoever the source of it is, would have an obligation to correct that. Yeah, so we've definitely done that for clients, written letters, and generally speaking, they've been, that is, the credit agencies, wherever it is, have been, other private companies have been relatively compliant in terms of correcting the record once they're notified of it. But so sometimes, yeah, that can happen, just because of the proliferation of information and criminal records, which is the reason for all of this in the first place, about how much they can get out there. Yes. Not through these statutes, no. Is there, maybe you could give a more specific example?
Well, if I'm giving you an example, is that
Yeah.
you just have a letter from the lawyer and you not that.
Yeah, so it's not going to get you different relief, but it makes a compelling argument as to why the court should grant you relief. I'll say that these are the statutory provisions that provide for relief. There are some earlier DC cases that we didn't talk about here just because we just wanted to get the basics here, but that say that the court has the equitable authority to seal records of a case, and you could certainly make the argument as to why this circumstance presents the case in which the court should seal records. I haven't had a lot of success with that, unfortunately, but that doesn't mean you couldn't try. And I think having evidence of the ways in which the record has affected the client would be make a compelling case for that. Yeah.
I also just wanted to let you know that we have a ton of clients who've already determined are eligible to have their records sealed. We've already gone through the process of going through the records, pulling them, and we figured out these things are eligible on interest of justice grounds. These things are eligible on actual innocence grounds. As another opportunity, if you are interested in this and you want to volunteer, I will work with you. Like, I can give you a case for a client who's been deemed eligible, and then you can help draft a motion for them. And we have samples that we can provide to you, and I'll sort of mentor you through the process. We can file it for you if you're a solo practitioner. But again, just another way of helping people that have already been deemed eligible, and just they need help drafting the motion if they don't have the legal expertise to do it.
Yeah. Yeah. There, as Catherine mentioned before, there aren't very many places in the city that especially provide free help with expungement. The Public Defender Service also does provide some help. Most of what they do, however, is sort of like helping people file pro se motions. And as you can see here, there are quite a few roadblocks, unfortunately, at which the process could get stuck. We've seen people file pro se motions and the judge not issue an order to respond for a year, right? So there's lots of places in which you could help that client get their motion ruled on and hopefully get relief faster. Yes? Yes, there are definitely judges who are, I would prefer to have a rule on motions than others. In terms of, that's another good point, I guess, is which judge the motion is going to go to. In actual innocence cases, that's going to go to the judge who presided over the case, unless they're no longer on the bench, and then there's an administrative order. They have a pairing judge that motion would go to. In interest of justice motions, it's going to go to the judge who presided over the most recent case that's the subject of that motion. Again, unless they're no longer on the bench, and then it's going to go to their pairing judge. So you don't really have a lot of control over who the motion goes to, but there are definitely judges that both act more promptly on the motions and give more favorable rulings without naming names. But yes. Yeah, so it's an appealable final order if the judge denies the motion, and is something that could be appealed. There's pretty limited case law in terms of like that happening. But yes, just like any other final order, it could be appealed. Yeah. Thankfully, we've been relatively fortunate in not in having a very high success rate of not having orders to appeal. But yeah, it's definitely an appealable final order. Okay, so just I mentioned that we wanted to come back to immigration here as a particular thing. I'm not an immigration attorney, but we created this with the guidance of someone who is. When somebody has a record sealed on grounds of actual innocence, the relief that they are entitled to is that they don't have to disclose that thing to anyone for any purpose, and they can't be found guilty of perjury or making a false statement for not doing so. And here's the big except, according to the immigration attorney, is that even if someone has been granted a relief on actual innocence, the advice that they have given is that that person should still disclose that arrest and that they were found actually innocent to immigration authorities. They should, of course, talk to an immigration attorney before doing that, before applying for any adjustment of status or anything like that. But that is a general exception to that. And in the case of interest of justice, it's going to stay available to the government and law enforcement agency anyway. So like they're going to see it. Period. There's not even a question, and you would have an obligation to if you were someone seeking immigration relief or asked a question by immigration authorities to disclose that to them. As it says, the immigration authorities are also going to request the outcome of the cases. So even if it's been sealed, somebody would still want to disclose that. Their recommendation also is that before filing a motion to seal for a non-citizen, that they would want to get certified copies of the record from that case. So we talked about before that if a judge grants a motion to seal records on grounds of actual innocence, that someone can still only have records of that case opened upon a showing of compelling need. So if somebody needed facts about that case and what happened for some immigration proceeding, just to make it easier for them, the recommendation is to request that information and get certified copies of it before filing a record sealing motion, so that you have those records and don't have any issue getting them, even though the person is still entitled to get those records under the statute, just to make it easier. The other things they wanted us mentioned are that, which is not directly record sealing, but since they've encouraged us to put it here, we can discuss it. Certain dispositions are still going to be convictions for immigration purposes, even if they're not convictions for record sealing purposes. That is, we talked about a deferred sentencing agreement where somebody gets to withdraw that guilty plea. That can still be a conviction for immigration purposes. We talked also about the Youth Rehabilitation Act. That's where somebody who is 22, or they haven't reached their 22nd birthday at the time of conviction, they can be sentenced under what's called the Youth Rehabilitation Act. If they do certain things, they can have that conviction set aside under some circumstances. But sealing the record doesn't change that the existence of that being a conviction for for immigration purposes. There are also other dispositions that can impact immigration policies and applications. Sometimes another form of diversion that's available, deferred prosecution agreements, where you're not required to plead guilty, but you have to acknowledge criminal responsibility or liability in some way, even without pleading guilty. That can also have immigration consequences. In terms of actual innocence motions that are supported by affidavits, those can be used against somebody in immigration proceedings, right? So somebody who's a non-citizen, you definitely want to If you're not an immigration attorney, you want to talk to an immigration attorney before filing any motion for them to make sure that you're not going to do anything that's going to interfere with their immigration status. And thankfully, this person has whose contact information is here at the Public Defender Service, who is an immigration attorney. It has said that they're available, and certainly if you're working with us and taking pro bono cases, we could help find an immigration attorney to talk to as well, if that was the case. But just something specific to non-citizens to consider. I know that went a little faster than I was thinking. Are there any questions? Yes. The breakdown in terms of like the numbers that we file, or like the success rate. I don't have those numbers off the top of my head, but we do both of them frequently. Yeah, I think probably, frankly, we do more actual innocence motions, and I think the reason for that is both the relief that's available, and just because, again, actual innocence motions go on a case-by-case basis, rather than filing one interest of justice motion that includes 10 cases, right? If you're going actual innocence, you got to file one in each case. So, so I would say somewhere about 50% of each, but maybe slightly more of actual innocence. Yeah. Yeah, so I think on the day of the event, we're going to also have that information, but maybe, Catherine, you could answer that question better than me, or if not. Yeah, so the question for the recording was administratively on the 23rd, how things are going to work. Are we doing intakes, or people are walking in? And I was just saying that generally we'd have that information on the 23rd, but I think the answer is that we will both have folks who we have records for already, and we will have folks who are walking in for the first time who are doing an intake for. And no. No, so we are probably going to be doing it with the exception of like looking up out-of-state records, mostly on paper for now, because I think that'll be the easiest way. Yeah. Yes. Yeah, so great question. So there is currently a proposal before the DC Council that was introduced, and I think now has 4 co-sponsors, that would radically change the record sealing laws in favorable ways. It would provide for automatic sealing of no papered arrests, the things that we talked a lot about before, which there are 10,000 or more of every year in the city. It would also provide for automatic sealing, it would provide for automatic expungement. So it would actually implement expungement here in DC for the first time. It would also provide for automatic, I don't recall for sure, but sealing or expungement of certain other non-convictions, shorten the waiting period significantly for convictions, eliminate some of the requirements or barriers that we talked about there in terms of like subsequent convictions, disqualifying earlier convictions. So there is a proposal before the DC Council that would do a lot of good things. It was introduced, I think, by David Grasso, one of the at-large council members, but now has an additional 3 co-sponsors. They haven't scheduled a hearing, which is the first step, the committee scheduling a hearing and doing the markup, the committee on the judiciary on the DC Council. They haven't scheduled a hearing yet. I anticipate that they will. I don't think that they're just going to sit on it. But definitely at that stage, we'd love to, and I'm sure the council member and others would love the support and feedback and testimony about that. So we definitely would be more than happy to let folks know when that's going on. But through the DC Council website, if you look at the legislation, there's a search function there. If you looked up expungement or record sealing, it was introduced in September of this year, and you can see the draft of the bill there. So the great news is that there is a really good bill that's out there, and there could be changes to it, of course, but it would be a terrific step in the right direction if it was passed in its current form. Yeah. Okay, well, thank you so much, everybody, for coming. I know that Catherine is happy to talk more to folks who might be interested in plugging in other ways. I know this was a little shorter than we expected, but that means you can all enjoy the rest of your evening and see us sooner on the 23rd. So thank you.